My name is Detmar von Hardenberg, and I'm going to be giving you a presentation today together with Steve Machetta on workplace and accommodation issues, when to disclose an accommodation or possibly when not. Also go through a little bit of some legal aspects of the laws out there that students need to know when they're leaving Landmark and entering the workforce, what's coming at them down the road, and things that they need to consider when disclosing or not their disability on the workplace. I graduated from Landmark in '97. After Landmark, I went to American University and I got a BA in 2000 and my master's in '01. I have 8 years experience working in the federal government. One year of those was working in sales for Jane's Information Group, so tiny bit private sector experience, a lot more government experience. I work in national security, and the comments that I'm making today are solely my own and are not those of the U.S. government. So disclaimer at the beginning. I was lucky to, through many, many years, having found my dream job, so to say, that popped in my head, probably my undergraduate class, and I was able to put in fulfillment almost 6 years later, 2 years ago, and a lot of that had to do with Landmark. But what I'm going to share with you today are the strategies that I noticed that I had to use. I had to adapt my strategies I learned at Landmark to survive at the workplace. Not only was this on the workplace, but for me, it was a special kind of workplace because it was a workplace where information is very close held. Okay, it was I work solely with classified information. I can't talk about my job, and that this environment was fundamentally different from the environment that I left in school. Having been able to tape record sessions during class, having note takers at hand. So a lot of the accommodations that Landmark taught me and that I used at AU completely fell flat in my workplace because I worked in a very special environment where this would never be allowed. So for me, it was a different set of skills and strategies that I had to develop while I was there, given the new environment I was in. And I'm going to go through a little bit today on how I adapted through this to be successful. And I think not only is that going to be something useful for someone who works in a national security position with classified information, but also with an individual who's going to the workforce and could be in any position whatsoever, because things will change once they leave Landmark. Another thing I also wanted to mention was that any student who graduates from Landmark is about to enter the workforce is going to be incredibly anxious. And I can tell you one thing, when I left this place and I was about to enter the even just enter AU or the workforce, whatever you want to call it, the anxiety was enormous. And to parents who have kids who are currently in school here or are going to graduate someday or whatever, that's something really to keep an eye on and also encourage your kids. It's going to work out. Just keep on plugging away. And also for students themselves to understand that you do have the skills that you learned here, which will allow you to become successful, and just not to get too anxious about it because it will work out. I just talked to you a couple minutes about the dream job that I basically worked myself into over years and years and years. But the important thing also is really I felt, never let your learning disability get in the way per se. It is extremely important to just understand that you are very talented in what you're doing. You've got the best education the world's got to offer for this, and you're on the best track to be successful. So that was my recipe to basically not only be successful on the job, but also to keep my confidence when I had to adjust my own strategies at work in dealing with a learning disability. So what am I going to be talking about? First thing is going to be, strategy time. You're leaving Landmark. Okay, it's a whole different ballgame. Okay, this in a way is a very protected area. Okay, you have got professors who are very understanding of you. You have a student body that's very, very understanding for you. In the workplace, that's going to be a different story. Okay, no longer you're protected. So what is your strategy going to be? I'm going to talk a little bit about that, what my strategy was, and what I recommend you to use as a strategy. Number two, I'm going to talk about scoping your surroundings. Number three, fight or flight. There are going to be a couple occasions I had one specific example one time where it was extremely uncomfortable and I thought I was being discriminated against in an employment situation, and I came like very close to filing a complaint, but you always need to keep your cool in the situations, and then it has to be like the absolute last resort, and I'll be getting to that a little bit further. And then I'm just going to touch off very briefly on the two probably most important laws pertaining to learning disabilities, and then Steve will go into much further depth into those since he's an attorney. And then I'll talk about when to file a complaint, when, according to my own judgments, because I almost did. And then and Steve will talk a little about the pros and cons of filing EO complaints. That's equal opportunity employment complaints. Because, I mean, one has to understand it is an option to do that, but if you do file a complaint, that will have consequences, even if it comes out in your favor. And that's something one just has to be aware of. And I'll go into that a little bit more detail later on. And then Steve will talk a little bit more about legal cases and accommodations in further detail. And then I got a couple minutes towards the end. I'm going to discuss about where to get help and where I found were some of the really very useful resources for myself when I needed it badly. So the bottom line is, are you going to disclose or not? That's a tough question. I mean, you will have people who will recommend either way. You sort of need to think, okay, what is the ultimate optimal outcome you can envision for yourself on the workplace? And what do you think your supervisor can do, let's say now for the federal government, can do in order for you to achieve that? But if you're going to tell anyone, in my opinion, then only tell your supervisor. And there's a caveat to that, which I'll get into a couple minutes later, because sometimes you may run into a situation where you cannot, not only should your supervisor know, but you may have another senior manager in your company or whatever, or let's say a product line manager, whatever, who may work below your supervisor, but whom you work with on a daily basis and who you may want to also tell as well. So there's a caveat to that, and I'll get into that. Then there's the issue of disclosing learning disability in an interview. I personally would not do it. Okay, that's a choice, but I have evidence to back up why I wouldn't do that, and I'll get into that a little bit as well. Because the thing is that any kind of decision you make, they'll eventually have consequences, either positive or negative for you. And also understand the difference between private sector, government, and nonprofit. Okay, you're going to have varying levels of sympathy and education when it comes to learning disabilities. My argument, I think the government would have a lot more understanding for it than maybe the private sector. I mean, maybe Steve could talk a little more about that and give us his opinion about that a little bit later. But you have to understand that given the job field you're going to be going into, there's probably going to be varying levels of, for lack of better words, sympathy or even understanding, and that's something to keep in mind as well. And then also, like I said, the filing complaint should really be the last option, but not only that, but also in your EEO office or wherever you're working, your support office, because every corporation or government organization is going to have an office whose sole job is to make sure no one is going to be discriminated against. Understand their chain of command. Who is going to be the person you need to talk to if you need to eventually file a complaint? Don't go tell them that. You just want to know ahead of time. Keep the individual's name on a piece of paper, so when that day may come, you know who to contact. And not just that, but if that person is not being responsive, who's the next person above them you can contact? So do your homework ahead of time to see, so this can happen fast and you can get the information quickly, because what can happen is that, like I had in one case where, and this may be more widespread in the government and other areas because sometimes we're a little less efficient. If you don't have a good working relationship with your EEO representative, they may just say, okay, well, I'm not going to talk to you anymore. So that's why you may want to know who's the next person in command, so you can completely circumvent them if you have to. So again, understand the chain of command in your EEO office. Who does what? Who's responsible for what? Keep their names and numbers handy. Okay, so you're entering the workforce. You got your new job. You've told your supervisor, but now you think, okay, well maybe, what do I need to watch out for? Scope your surroundings. Keep your eyes open. How sympathetic are your work colleagues in general towards not just learning disabilities, but any issue? You could be talking at a lunch table. You'd be talking about Hurricane Katrina. Okay, I remember one time I was working national security. Well, I was working in the Pentagon at the time, and there was a discussion about Hurricane Katrina, and the guys who I was around weren't very sympathetic about what was going on there. So I knew immediately that if these guys were going to have and not very sympathetic towards the situation in New Orleans, I didn't have to begin to talk about an LD issue. Okay, and that's like what I'm saying. Scoping, so that way, okay, that person does not come into question. How competitive is your profession? That's another big issue. Are you a stockbroker on Wall Street? Are you working in sales? Are you doing research? Or are you a teacher? I mean, that is going to vary, and that is also going to have an impact on how receptive your colleagues are going to be to a potential disability, or I should say, how understanding or not so understanding they may be. Because in a competitive environment, as we all know, I mean, it's you against them a little bit, and if you tell someone in a highly competitive job that you have a weakness, well, that could be a problem on the road. So that's something to keep in mind. Keep your eyes open for potential allies. This is probably like one of the most important things I learned. And again, this has to do with, who could be a potential surrogate landmark person. I mean, you would never go into that kind of depth in telling them that, okay, well, you just remind me of my landmark professor. No, but there are people out there who are very helpful just by nature, and you want to recognize those people. I mean, at least know who they are. So, if you are going to tell someone beyond your supervisor that that person will be an option. Again, I talked about the EO command chain, and then if you're going to switch your job for whatever reason, let's say you can't stand your job and the accommodations aren't working out. With the new job, who is your supervisor? Who's the supervisor of the new job you're looking at? Do your homework and find out what's their track record when it comes to general empathy, I would say. If they're a person that's just a person who's like a hard nose on a lot of issues and doesn't want to budge, and doesn't really, give you the vibe that is very accommodating, you may want to reconsider that, because they're probably not going to change when you work for them. And one other thing I also want to mention really quick regarding your scope of your surroundings and also with your supervisor, there's a very, very good DVD out there called How Difficult Can This Be? And it's from the Fat City Workshop. I'm not making any money off this when I'm saying this, but what I can tell you is that this is the best video out there, or DVD, to explain what it's like to have a learning disability to someone who has absolutely no idea. And the reason why this is so important is because, number one, it's not easy to explain. And number two, don't ever let someone else explain it, because they will most probably get it wrong. And then they're going to say, well, he has trouble walking or whatever. No, he's actually just dyslexic. But you'd be surprised, like how far they can veer off that. But you want them to get it very, very accurate. So I have it on my job, and one of the people who I worked with was so impressed by it that they actually bought additional versions of that for the federal government. Okay, and again, I can put out I can make some photocopies of the name of this DVD, but it was so good. And actually, in fact, I think the speaker actually came here at some point and spoke, and it just in very cogent terms and also very good scenarios, described something which I frankly could never describe to my supervisor or to a supervisor, and it was very, very useful. And also remember, with potentially filing a complaint, is that there are many different things you can do prior to that, before you actually go that far. Whenever you having had a dispute, have a one-on-one conversation with them first. Try and work things out at a much, much lower level before you can go that high, because that is something that when you do file a complaint, it's going to be known by many people. Like I said, your new workplace scenario, you keep your mouth shut, your eyes and ears open. You really need to focus 100% on your work. Okay, no matter what you tell any supervisor about what kind of disability they have, that's all going to be fine. Okay, well, we all have our cross to bear, so to say, but you have got to also put yourself in the perspective of your employer. Okay, because for them, they're going to want you to work well. So become a perfectionist. And sometimes people will say, or students may say, I have no idea what I want to do with my life. I don't really know what I like to do. because it's important to find a job that you're, number one, good at, and number two, that you can excel at. And how do you do that? You read the newspaper from front to end. And at any story that you go back and look at a second time, that might be a hint. You might be interested in that field. Is it sports? Is it medicine? Is it national security? Is it politics? That's how you start honing in on what you're interested in, and it gives you a hint on the kind of job you may want to engage in later on. And another source would be also like the Johnson O'Connor Institute, which does aptitude testing, and I can give you some more information on that a little bit later. But also, being aware that there are institutions out there that will test your aptitudes and ensure, or at least increase the chances that you are going to be more tailor-made for your position, because you are going to need that. You're going to need that extra stimulation to be successful, because things are not easy for you to begin with, and there's no sense in making it harder. By picking a job, it's going to be more difficult. It's a non-visible condition. It's hard to explain. The DVD I just mentioned, I just showed your supervisor. It will answer a lot of questions, which is what you don't want. You don't want questions coming to you saying, okay, well, what did you mean again by this? You just sent me an email describing dyslexia? No, just show them the DVD. Done deal. And also disclose to others only if you really have to. Like I mentioned a little bit earlier, if you see that maybe you're in a work scenario where you're not only working with your supervisor on a regular basis, but also some other individuals who may need to know, because during your evaluation, your supervisors could ask some other line managers on how you're performing. Some line managers who you're working with, you may want to tell them as well, but only really when you must. And there's a really fine line here, because if you say too much, if you talk too much about it, you risk being labeled as a whiner, and that is not to be underestimated, okay? Because people will turn you off like the worst 60s song you heard in your life after that, okay? Because it's going to irritate them, and they're going to think that that you just want something special no one else has. Just when you follow these steps, it's going to make life for you a lot easier. And I've also got some cards laminated here for the group that you can stick in your that you can stick in your wallet, which will summarize all the points which I mentioned in this presentation. So you can take that home with you. Now, pick your battles. This is another really important one. You're bound to be in situations where people are not going to be very receptive to what your problem is or what your situation is, but that is not going to immediately warrant you to come at them with a complaint, for instance, okay? Because a complaint is a big deal, and Steve's going to get into that, okay? And it should only really come in very specific circumstances, which I'm going to get into in a couple minutes. But you also have to ask yourself, okay, what is the battle I really want to fight? What is the ideal scenario? What is it that I need to succeed, which I do not have right now, okay? And that is the battle that you want to fight, no other battle, okay? And also, don't forget, nothing is ever 100%, okay? You have to seek the 90-10 solution. And what that means is that often, no matter how hard you work, you'll probably not get 100% out of your job what you're looking for, okay? So stop spinning your wheels in the mud and trying to constantly perfect yourself to such a level where everything's going to be fantastic. That means my colleagues are going to say, oh, you graduated from Landmark, oh, great, I love you, and all this kind of stuff. And then, oh, you did this and did that, and you had such a hard time, all this kind of stuff. It's not all going to be like that, So don't spend like the last 10% or last 10% of your time looking for information looking for a situation which you're probably not going to find anyway, okay? So just you have to compromise a little bit, So you may not have a 100% situation on the job where, everyone is just totally, loving you for what you've gone through, but settle for a little bit less and you'll be fine. So now we come to the big one, which I call going nuclear, filing a complaint. Briefly explain the situation where I was in, where I came very close to doing this. I think by any different definition of the word, I don't think anyone in my workplace would consider me a person to make rash decisions. But I had applied to a position where I had mentioned my learning disability, okay? And I had just the best interview ever. The guy was impressed with me. It was a lateral position where I worked, and it was very impressed with me. And looked at my past accomplishments and said, okay, you'd be a great match or whatever. And he said, oh, we'll get right back to you. And this was a job that was very hard to get, extremely competitive job. Okay, and then out of the blue, I found out I didn't get this job. I'm thinking, what? I didn't get this job? And I'm thinking to myself, oh, you know what? I should have never said that. And this was like a huge deal because this was a job where it was basically like a dream position for myself. And I was kicking myself that I had mentioned during the interview, okay? So I talked to some, again, trusted allies, mentors who I sought on my workplace and said, hey, listen, did you hear about this? What do you think? Took them aside. I located a sympathetic work colleague who I scoped out before, okay? And asked them this, and you can find maybe 2 or 3 when you're in the workplace. And through a course of several days, we came to the conclusion this might have been a disclosure issue, okay? And that's why it's important when you're in a situation as serious as this that you talk to many different people. It's just like President Obama, he talks to many advisors before he makes any kind of decision that potentially has significant consequences. I did the same thing, and then these guys brought to my attention and said, you know what, you should not have said that. And it would never even have dawned on me. So anyway, make a long story short, I had already contacted the EEO office. And I was already telling these guys, okay, you can get the jets in the air because I'm about to, because I figured that because nothing else made sense. The application was very strong, and there was no reason why I should not have gotten the job. Everyone agreed with me. And literally an hour before I was going to file this complaint, I got a call from the interviewing supervisor who told me he couldn't hire me because of lack of funding. Okay, and that's where you got to be careful. Okay, but I didn't know that. And even if had I filed the complaint, they couldn't really blame me. But it still would have had potential consequences for me. And what I mean by consequences is that when you file a complaint, and I don't want to discourage it because there are cases where you do need to file it, okay? And that is, is your performance actually suffering on the job? Are you at the point where your accommodations on the job are so poor or so inadequate that your performance evaluation is suffering, which can hurt you for the next promotion? That is when I would file it, okay? That means when your boss tells you, okay, Debmar, this is just not working out. I'm giving you mediocre ratings, okay, for your last performance cycle, and then you think back to myself, okay, wait, you're giving me mediocre ratings for the last fiscal year, and I can't work because this guy is so loud next door with his stupid radio, and I got earplugs in my ears, and I still can hear the guy, and I've done everything that I could, and management has been repeatedly unresponsive. That's when I go in for the kill. Because I don't have any other choice at that point, And I think that is when it really justifies, when you see your performance is suffering on the record, it's time to act. And that's just what I think. And then when you do that, I recommend it, but it's going to be a seismic effect in the office, okay? Because what that means is that this office is going to contact your supervisor. They're going to call them and say, okay, Mr. So-and-so, you're X, Y, and Z, supervisor. We are an investigating office, and we heard that there's this going on, and that's going to spread. But it's fine. It doesn't make it. I think it's a good thing to go ahead and do it if you are really suffering from. If your performance is suffering on the job, I don't care who knows, but I'm not getting that stuff on my record. And now I'd like to go over a little bit where to get help. There are a couple websites here which are, I think, very important. Again, there'll be copies of it towards the end of the lecture. But the 2 ones I really want to focus on the most are the Americans with Disabilities Act website, but also the Johnson O'Connor Research Institute. That is, you want to flag that one, in particular for mothers who have kids, in school at Landmark, or if you know someone who's just struggling to just find their direction in general, what kind of job they want to go perform in. that institute will test their aptitudes. And that is so important for LD students, because if you land into a job which you're naturally good at and yet you like, you'll probably not even have to worry about this stuff because it's never going to come up. Okay, it's only in situations where, you know, in professions where you're running up against situations or daily tasks which are going to challenge you because of your learning disability. You know, but the better that you are at your job and the more easier it comes to you, the less likely the chance will be you'll ever have to be involved in the EEO process. This is pretty much nationwide. They're all different disability law centers. In fact, you know, I just picked them out by region because I thought, instead of typing out 50, I thought I picked a couple of states, and hopefully these will be useful for you. Anyway, so the conclusion is just basically, you know, don't worry, think positive. I mean, your employer hired you for a reason. They know that you can do the job, you know, but if you keep these factors involved that I just mentioned to you a couple minutes ago, and take one of these little laminated cards with you, which we have here as well, stick them in your wallet, we'll let you know what to do if you do get into a pretty hot situation.
Thanks, Detmar.
Sure, no problem.
I'm not going to go over any of this, my background, but basically I'm going to be discussing very briefly the civil rights laws that are relevant to our conversation today, and basically go through the background, how we got to where we are today, which is we have the Rehabilitation Act of 1973, followed by the Americans with Disabilities Act of 1990. And I'm going to talk about how the courts have construed the law and what has occurred as a result of those holdings and the construction by the courts, which prompted the Americans with Disabilities Amendment Act of 2008. Finally, I'll talk briefly about filing a charge of discrimination. So this is basically what I'm going to talk about. And a background of the civil rights, we have to go back to 1957 to the Civil Rights Act of that year, which was basically a response by Congress to the Supreme Court's decision in Brown versus Board of Education, which held that the segregation violated the Constitution of the United States, the 14th Amendment in particular, which was a predecessor of the Civil Rights Act of 1964, which we all call the Civil Rights Act, which prohibited discrimination based on race, color, and national origin. The problem is it was limited only to programs receiving federal aid. And then finally, the Voting Rights Act of 1968 was part of the lead up to the ADA. In terms of what occurred first was in the federal government, the Rehabilitation Act of 1973, and specifically Section 504, prohibited discrimination on the basis of disability for an otherwise qualified individual. And again, that dealt with entities that were either federal agencies or received federal financial assistance. It was the first rights legislation to prohibit discrimination against people with disabilities. But again, it was limited to federal agencies and those receiving federal funds, and it did not protect people with disabilities from discrimination by private employers or by public accommodations in the private sector. So what we ended up with finally in 1990 was the Americans with Disability Act that was signed by George Herbert Walker Bush on July 26th of 1990. It was the first comprehensive civil rights law for people with disabilities. Now, it was intended to address and provide remedies for disability discrimination by employers, state and local governments, public and private transporters, in the different titles. Basically, I'm going to be focusing on Title I primarily and some of Title II. So Title I applies if you're an employer with more than 15 employees. First of all, you can't discriminate, and second of all, you have to make accommodations. The definition of disability, you would think, well, why is this so important? Well, when I talk a little bit more about the cases, this is where the fight was. Whether or not you were entitled to any remedy was basically, the war was being waged as to whether or not you fit within this definition. A physical or mental impairment that substantially limits one or more of the major life activities of an individual, a record of an impairment, or being regarded as having an impairment. One of the first cases that really came down against individuals with disabilities was in 1999 when the U.S. Supreme Court in Sutton versus UAL said that a determination of whether an individual's impairment substantially limits, remember we were talking a minute ago about substantially limits one or more major life activities. Well, they construed that to mean, first of all, you can't make that determination in a vacuum. You have to do it with reference to any mitigating factors. For example, if I have a visual problem, but I can correct it with lenses. If I have ADD, but I take medication, then all of a sudden you don't have a disability. Well, that's basically what the courts were holding. What was worse was in 2002 when the United States Supreme Court equated the phrase substantially limit to prevents or severely restricts. So a substantial limitation now became something that basically impeded your ability to do anything, which is putting the bar up so high that it can't be reached. There were other decisions throughout the United States. For instance, even in 2007, an individual was diagnosed with mental retardation, failed to provide evidence that he was substantially limited in any major life activity. I mean, you see how preposterous this is? Well, that was in Littleton versus Walmart stores. Then in 2005, an individual who performed well academically in Wong versus Regents of University of California could not be considered substantially limited in activities such as learning and reading. Which again, craziness from my perspective. As recently as 2006, in Ohio, I think this was in Columbus. The Sixth Circuit held that if you can control ADHD with medication, then you're precluded from a finding of disability under the ADA. Therefore, whether or not you've been discriminated against is irrelevant because you never even get into the race, much less get to the finish line. So, the long and the short of it is that in most instances, the courts never reached the merits of the case. In other words, whether there was discrimination, and we can even start talking about accommodations because the courts so narrowly construed what a disability is or what substantially limits means that these individuals, unfortunately, from 1990 until 2008, basically had no redress because that almost 20-year period, they never got to the merits of the case. So what happens? Thankfully, Congress intervened in 2008, and they had taken a look at all of these court rulings and finally said, this is crazy, this is not what we intended. So what was signed into law was in 2008 was the Americans with Disabilities Amendments Act, the ADAAA of 2008. It was signed into law by George W. Bush almost this time in 2008, and it became effective in January 1 of 2009. So you were going to ask questions about, well, what type of accommodations? Because even though we had 1990, the Americans with Disabilities Act was signed, when we start talking about what types of accommodations there are, the majority of people who had any kind of disability, unless, like the ones that I talked about earlier, we never even got to talk about accommodations, which is sad. And a lot of people they were not able to keep positions and they were not able to hold jobs and were terminated for probably no very good reason, probably bad reasons. But Congress sought to remedy that with the ADAAA in 2008, and they specifically in the comments to the act said, the focus should be shifted from whether or not a person has a disability. Let's move beyond whether the disability exists, and let's get to whether or not discrimination on the basis of a disability has occurred. Now, one of the things that the act specifically included was a list of major life activities. Because the courts had been talking, well, what's a major life activity? Is it reading? Is it not reading? Is it sleeping? Is it thinking? Is it concentrating? Well, if you can take a look at this, you will see that a lot of what's on here is very important to people here at Landmark in terms of thinking, reading, concentrating, communicating. When you talk about executive functioning, and not to mention dyslexia, it hits the nail right on the head for us. And they made sure to include a statement that this list is not intended to be exhaustive and that there may be other life activities, such as interacting with others or writing, that might be considered a major life activity, which who wouldn't think that in the first place? Well, the courts didn't. by accident or design. I think it's by design. And they also said in the ADAAA that an individual is not excluded from coverage because they're able to perform many activities so long as they are impaired from performing or they're substantially limited in at least one major life activity. So it was no longer a defense to say, I understand that you can't read, but you can walk and talk just fine. And in the cases that we talked about earlier, they specifically repudiated the holding in Williams, which said substantially limits equals prevents or severely restricts. Because that was not the intention of Congress when the ADA Act of 1990 was written, to take a substantially limit standard and put it up in the stratosphere so that no one can reach it. And it also partially overruled the holding in Sutton and said that, you'll recall that in Sutton, the court said that if there are mitigating factors, then you're not disabled. In other words, if you can get Kurzweil and everything's hunky-dory, well, then you're not really disabled. This specifically said, it left the rest of the holding intact, but it said that you are not to consider mitigating measures in determining whether or not someone has a disability. Because you can mitigate the effects of it doesn't mean that it's not there. Filing a charge of discrimination is something that is very, very serious and should not be entered into lightly, as Detmar indicated earlier. I'm going to be talking about basically filing a charge in 3 different scenarios. One is against a business employer, which is Title I of the Americans with Disabilities Act, and this is all in the handouts in greater detail. A state and local government, which is Title II of the ADA, and then, as Detmar talked earlier, about federal government employers. That's the Rehabilitation Act of 1973. So what's the complaint process in Title I? Well, you must file the complaint, or what's called a charge of discrimination, with the EEOC within 180 days of discrimination. Now, if you're out trying to figure out what to do, if you've been at Landmark and you have a disability, go onto this website and find the local EEO office so that you know where to go. Forms are available online, but you're going to want to know where they are and how to get in touch with them. The complaint, there's a form for the complaint that makes it very easy to complete and file so that all the information is there, but if there is some piece of information that is not there, it will not be considered filed, and you might miss a time period of 180 days. So the complaint has to contain your full name, address, telephone numbers. It's got to, obviously, the things that are listed here, the name, address of the business or the institution that you believe was discriminated against you. Obviously, there has to be some brief description of the actual discrimination itself. And I would say, the who, what, where, when type information is what you need. And anything else that might support your complaint, including any kind of documentation. What happens after you file? Well, the EEOC can investigate your case, but typically what they're going to do is they're going to try to informally resolve the case through what's called ADR, Alternative Dispute Resolution. And this is typically mediation. The EEOC hires attorneys, employs attorneys who do nothing but act as mediators. And that is to say that they will get the parties together, get the information from the employer, what happened. They will talk to you as the complainant. What do you believe occurred? What is the discrimination that you believe occurred? And they'll take a look at it. And they're not going to offer any opinions about your case. All they're going to try to do is see if there can be some resolution between the parties. And that generally is going to either involve a reinstatement of some sort or money. Now, if the case does not settle, the EEOC is going to decide whether to bring a lawsuit on your behalf. If the EEOC does decide that they're going to file suit, they refer the case to the Department of Justice. The Department of Justice, they can either initiate the lawsuit right then and there, or they can say, we understand what the EEOC said, but this is not something that we're willing to get, we're going to pursue, and they'll issue a notice of your right to sue, which is something that you have to have in order to proceed on your own behalf to make a charge of discrimination in a lawsuit. Now, if the EEOC says that we're not going to bring a lawsuit, which in a lot of cases is the way it works out, you're going to still get the same right to sue letter, which again is a prerequisite to filing any lawsuit. If you file a lawsuit, and there were plenty of them filed, where Unfortunately, the claimant was obviously discriminated against, despite all the rulings saying that he might not be disabled. But again, the court never gets to it because guess what? You didn't have the right to sue letter. So you have to allow the administrative process the opportunity to run its course. If you don't allow that process, you're out. Once you get the right to sue letter, you have to act within 90 days. If you don't file a lawsuit within 90 days, you're going to be time barred. So there'll have to be some more discrimination that was not raised in your initial charge with the EEOC that you could then proceed on. But in all likelihood, you're going to be in trouble if you don't file within that time period. Title II talks about the ADA as it applies to state government and local government entities. I'm just going to give you a couple things on this very briefly. You can file an online complaint for that, and it's got to be done generally within 180 days of the discrimination, although some states have an extension to 300 days. If you're a federal government employer, you do not file with the EEOC. Each federal agency has its own EEO, Equal Employment Opportunity Office. So just as Detmar said, when you get the job with whatever agency, Department of Justice, whatever, go find out. You better find out who the EEO, where the EEO office is for that agency, because any complaint that you have is going to have to go there. If you feel like you've been discriminated against, you must contact an EEO, the EEO counselor for that agency within 45 days of the act of discrimination. You can choose to participate in counseling or in aid, which generally takes place within 30 days of your complaint or notice to the EEO counselor, and they're going to try to do this counseling business where they're going to engage in what's called an interactive process, where they're going to try to work out whatever problem there may be. Or within 90 days of you filing your charge or notifying your EEO counselor, they'll do the same type of alternate dispute resolution to try to have some informal resolution of the charge. Now, what happens if that fails? If the counseling doesn't work, or if you've done the ADR, that doesn't work, then you're obligated to file a complaint with the agency. Now, once a complaint is filed, the agency must conduct an investigation unless the complaint's dismissed right off the bat. Now, once the investigation is completed by the agency, the complainant, that being the person who's been discriminated against, can request a hearing in front of an EEOC administrative law judge, or can ask for an immediate decision from the agency as to whether or not there's been discrimination or whether they can be reinstated. And that decision is appealable, and there are time limits for all those things. If I haven't said it already, I've been thinking it. Please, if you even think that you're being discriminated against, call a lawyer immediately. Do not try to go it alone. If you do, you may miss some deadlines. You may say, well, you know, I have this brochure from the company, and it says exactly what I have to do. You need to know your rights. And the only way to do that is to hire an attorney. Detmar talked earlier about the nuclear option, when to file a complaint. In terms of, if you were to come to me, and employment law is not my specialty, if you came to me, I would tell you, as would I probably imagine any other lawyer who does employment law, would want you to have disclosed the disability as soon in the process as possible. Not necessarily during the interview, clearly, because there are implications to doing that. They just won't hire you. Once you get the job, Detmar is going to say, be very careful about filing the charge, or you've also said, be very careful and discreet about who you mentioned to. Who you talk to. Just know that from my perspective, once it's hit the fan and they're trying to get rid of you, or they have already gotten rid of you, just know that if you come to see me, I'm willing, on the front end, I'm going to encourage you to tell them about the disability immediately so that they can start this interactive process, which is, what do you need? What can we do to accommodate you? And the sooner you start that conversation, the better. Because what will happen is, once Detmar said, if you notice your evaluation starting to suffer, here's the problem. If you wait until then to disclose the disability, and you've had no accommodations up to that point. Disclosing the accommodation is not going to take that bad report out of your file. So if they want to get rid of you, if they do want to get rid of you, ultimately you can say, I have a disability and you can try to accommodate me now, but guess what? Your employment file is already polluted with all of these bad reports. So, you know, it's a fine line. And so that I would leave you with that, and Detmar has a couple closing comments.
One thing just popped in my head again, which is very, very useful and extremely important when it comes to any kind of, I guess, like an emerging storm or in the works when you're about to maybe file a complaint. When you're talking with the supervisor or with anyone else regarding the issue that you're having, regarding accommodations or any kind of disagreements, you want it all documented, okay? And the way you do this is you write emails. You don't talk in person. Because when you talk to Steve, he's going to see the evidence. He doesn't want to hear about this because you can't prove this. You have to lure them away, okay? It's a little deceptive, but you know what? You have to do what you got to do. You want to get an email exchange going on, so if it ever does develop into a lawsuit or something like that the attorneys have something in hand that they can say, okay, no, you didn't say this. We know because I've read this email, okay? And that's what you want. You want it written down.
Any questions? Comments? Spare change? Just kidding. Thank you.